Hi, good afternoon. This is Diana from SunRay Construction Solutions. But welcome to the What Happens After I Record My Lien, How Do I Get Paid webinar with Ted Laperouse. Please, Ted, take it over.
Well, good afternoon, everyone. I was asked to give a talk on what happens after a lien is filed, and I wanted to start with the question: what is a lien exactly? A lot of people know that a lien, when you file it, it can help you get paid, but what is a lien? A lien is nothing really, and in Louisiana, we sometimes refer to it as a claim of privilege, but it's just that. It's a claim to an interest in a movable property or money in the hands of somebody else for work performed. And so when a lien is filed in the mortgage records of the parish in which the work was performed, the lien serves to put the world on notice that you have a claim, a lien claim against that piece of property or the funds that are used for construction. And once the lien is filed in the mortgage records, clear title to the property cannot be transferred absent a cancellation or extinguishment of that lien. And so that's why a lien is a valuable tool. It's an extraordinary remedy because it allows someone to make a claim to security, even though that person may not have a contractual relationship with the party who owns that property that you're filing your lien against. But because of that, the legislature determined that you've got to follow very strict guidelines, which are contained in the Louisiana Private Works Act, which is Louisiana Revised Statute 94801, in order to secure that lien. So the question of the day is, okay, I filed my lien. Now what? What do I do? What does that mean? Again, as I mentioned, a lien is just a claim. It's just a claim. In order to perfect that lien, in order to really make it have teeth, you've got to seek adjudication or foreclosure of that claim. And you do that by filing a lawsuit. And the statutes require that if you don't file your lawsuit to foreclose your lien that you've already filed, so again, you filed your lien in the property records, now you've got to file a lawsuit with the court, the parish in which the property is located, but you've got to file it within 1 year of that lien being filed, or the lien is extinguished. So it's almost like a two-step process. But and of course, if you're filing a lien and you're doing it pursuant to the proper procedures, you know that you've got to provide notice of the lien to the owner by certified mail within that lien period. And just as a recap, general contractors, generally speaking, provided you file your notice of contract, you've got to file and serve on the notice within 60 days of substantial completion or notice of termination your lien. Subcontractors, if a notice of contract has been filed, you've got 30 days from substantial completion or notice of termination to file your lien. If no notice of contract has been filed, you've got 60 days from substantial completion. And it's a good practice to make sure that you notify the owner and the general contractor, but the owner is the one that's the most important. Second tier subcontractors or lower subs or suppliers must provide notice in addition to the owner to the general contractor for the project, and you've got to do that within the same time frames. So within 1 year after your lien is filed, you've got to file a lawsuit. If you're a company, you will need an attorney to do that for you. In Louisiana, a company cannot be represented, or excuse me, a company cannot be represented pro se, which means by an individual. So you would have to have an attorney represent that company. That attorney would file your lawsuit. It's typically brought along with a lawsuit for breach of contracts. Essentially the breach of contract is what in the contractual claim is what gives rise to the claim of the lien, because there's got to be an underlying debt for that lien to be able to attach. The lien simply gives security in the form of the immovable that was improved or construction funds in the hands of the owner or general contractor. And so the suit that you file is essentially step 2 of the lien process, right? You're seeking a declaration by the court that the lien is valid and should be foreclosed upon. And provided you go through the lawsuit, you're able to prove your claim for breach of contract and lien foreclosure, that you properly complied with the rules in filing and perfecting your lien. The court then rules in your favor and will issue an order for the sheriff to seize that property and sell it at judicial sale. And the proceeds from that sale are what's used to pay off the debt that's owed to you by virtue of the lien. Now, this is more theory, right, than in reality, because it's very seldom that liens are actually foreclosed for construction purposes. Typically, the case is going to settle before that, or if a judgment is received before the sheriff has to go seize that property, typically what's going to happen is there's going to be a payment made, because an owner doesn't want to have their property sold at judicial sale. But that is essentially the theory and the policy behind a lien. It gives security, it gives an asset that you used, that you improved with your labor and materials. It gives that asset as security for the debt that's owed to you for your work. But there are some pitfalls or obstacles that can be in your way when you're trying to foreclose. First of all, the owner or the contractor may contest that your lien was not in the right form. You didn't comply with some of the requirements of the Private Works Act in providing the content in your lien claim. They may try to attack the timeliness of your lien claim if you're late in filing it. Or they may try to argue that there is no claim, the claim has been extinguished by payment or some other sort. Maybe there was defective work or some other defense that an owner may have. So you've got to go through and actually you've got to prove your claim, your entitlement to that debt in your claim for foreclosure of your lien. If there is an attack on the form or timeliness of the lien, the owner would proceed by a summary proceeding, which is a very quick procedure. Again, and that's only for things like you missed your deadline, you didn't comply with the statute on content. Very quick, easy to understand issues. If the claim is based on, or if the dispute centers around the merits of the work or the labor materials that you furnished or the amount of the debt, that would go to, that would be handled in the ordinary proceeding that you would have filed in order to foreclose your lien. Another potential obstacle, or something that everyone who files a lien should be aware of, is that an owner or contractor may bond around your lien. And that's not necessarily a bad thing. What happens is any interested party can go and obtain a bond from a surety and pay to have that surety put up the money, the security or the collateral, such that your lien claim is protected. And if they do it properly by statute under the Private Works Act, the owner's property is no longer burdened by the lien. It's removed from the lien claim, and the security now is against the bond that was furnished by the contractor or whoever did bond around the lien. You still have to prove the validity of the lien claim, the validity of the lien claim, and that the debt is owed. But you have a solvent surety on the other end of that, such that if you do prove your case, you've got a bond that's going to be able to pay for the debt. Another issue to be wary of as a lien claimant is that if the owner is a tenant or simply a lessee, excuse me, a lessee of property, your lien does not attach to the actual property itself, but only to his interest, that owner's interest in the property, which if he is just a tenant, it's going to be the leasehold interest. And so if you were to sue to foreclose on that leasehold interest, all you're entitled to is to assume the continuation of the lease. That can be an effective strategy to get paid sometimes, because most of the time the tenant does not want to be evicted and doesn't want you taking his lease over. But you have to understand that there is no hard asset to seize and sell other than the leasehold. So that's essentially the mechanisms or the procedure that one would take once a lien is filed in order to get paid after that lien is filed. Does anybody have any questions?
Hi, Ted. It looks like there are no questions at the moment.
Okay.
Yeah. So if we are all done, we appreciate your time, and please feel free to give us a call. If you could put our information on the screen one more time, Ted, so they can see our email addresses and phone numbers, and they can just contact us, reach out to us whenever they are ready with a question. We'll be happy to respond.
Okay. All right. Thank you very much.
No, thank you all for your time. Have a good one.